SJC-12936, Commonwealth v. Edward Gonzalez.
Okay. Attorney McMahon.
May it please the court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. This is a case on further appellate review of the Commonwealth's appeal of the order suppressing the defendant's statement, his custodial statement on May 26th of 2016. The defendant had been interviewed after being arrested on a charge of murder for about 20 minutes. He invoked his right to counsel. The interview suspended. Because he was charged with murder, he couldn't be booked with regular prisoners and was held in the detective bureau until the booking officer would give him permission to be booked downstairs.
And that's in the record, right?
Yes. And one of the two detectives who had been interviewing him in the first 20-minute interview sat with the defendant in the interview room while they were waiting the order to take him down to booking. They did ordinary chit chat.
Well, Ms. McMahon, can I stop you there with the ordinary chit chat, which we don't have a video of, obviously,
No.
the general talk. So I had a chance to look at the video, and things are pretty hot at the end of the first interview.
Absolutely.
Go into the second interview, and it's just the most cursory ahas to, yeah, I said I wanted to talk again after he got out of the bathroom. Well, isn't Judge Ferrara just saying, okay, let's look at all the circumstances here. We have no evidence of what this general talk was, the nature of all the evidence, and this just doesn't meet proof beyond a reasonable doubt. That's what he's saying as a fact finder. I've looked at it all, and this just doesn't reach proof beyond a reasonable doubt. Forget Tremblay, that's what he's saying based on not just the video, but the lack of evidence and everything else that came in evidence.
Well, he didn't look at all the evidence. He only looked at what Detective Pogorski said at the beginning of the second part of the interview. He didn't consider the defendant agreeing that he had decided on his own to re-interview. And Detective Canini brings that up again in the second part of the interview, and the defendant agrees again. So the defendant twice corroborated what Detective Pogorski said. And we have something about the conversation was in the interim between the first and the second interview. The defendant asked what happened next, and Detective Canini explained the booking process to him. He didn't recall the other parts of the chit chat, but he did specifically recall that he did explain the booking procedure to the defendant, and the defendant decided that he would be re-interviewed.
Well, there's a huge inference at the end of the opinion, Judge Ferrara's opinion. And I know that the subjective views of Canini are not, to say the least, dispositive. But the inference that Judge Ferrara adopts is that this general talk was, these aren't his words, the functional equivalent of interrogation in order to get the defendant, despite his invocation of the right to counsel, to indicate that he wants to speak again. That's the inference. So,
From what?
So
Detective Canini said they didn't talk about the case.
Well, that's my question.
You can't draw an inference the other way from what he said. There has to be some evidence of it. And the Torres case, which is cited in my brief, is on point. The judge in that case made an inference that the detective was, his question, talking to the defendant was designed to get the defendant to talk, but there was no facts to support that, just like here. And so one, not only was it wrong because it focused on the detective's subjective intent as opposed to what the defendant perceived, but two, there were no facts to support it. And that's the same situation here. He's drawing inferences from the opposite of what he is concluding.
Mr. McKeon, is it true that Judge Ferreira found the police officer to be credible?
Yes, he said that Detective Canini would be, his testimony would be sufficient if it was a preponderance standard. So that means that he didn't discredit him. He never says, I disbelieve him.
Is the bottom line, I guess the appeals court said this, and you argue this, is that the motion judge seems kind of bothered by the aggressive question in interview number 1, and engages in speculation as to its import for interview number 2.
Yes. He's speculating that Detective Canini continued to either act aggressively during that 40 minutes or did something else to try to get the defendant to change his mind. But the detective testified contrary to that, and there's no evidence that there was any kind of overreaching.
But aren't there, Justice Gaziano, are you done? Sorry. But there are a couple of different things happening at the same time. The detective is very angry when the defendant exercises rights. Doesn't he slam something down or something like that, right? Is that right? He's aggravated at the end of when the guy exercises his rights.
I think the captain comes to the doorway and he's the one who is really yelling at the defendant. He wasn't one of the 2 questioning detectives.
I thought the Spanish-speaking officer, and again, if I'm confusing with a different case, let me know. I thought the Spanish-speaking officer who's left in the room is also aggravated at the end of the interview. He slams something down or something to that effect, or am I misremembering?
I think the defendant tries to say something and he's like, no, you asked for a lawyer, you can't talk. He's like harsh like that at the end of the interview. I don't recall him slamming anything, but.
Okay, but I'll ask that to Ms. Elkin. But then we've got the tape recorder goes off. The only person left in the room is the Spanish-speaking officer. The Spanish-speaking officer doesn't remember what he says. He's not. So we can't credit what he says in there because he doesn't remember except for its general talk, whatever that is. The captain has just come in and given the guy a screaming at. All of those, don't they suggest maybe there's something a little fishy here, and that the trial judge, the motion judge can take all this into account in deciding whether this has been proved beyond reasonable doubt, whether this guy was pressured into, talking again. I mean, it just doesn't seem like a big leap to me, given all of these things happen at the same time. So I'm not sure it's a credibility finding so much as, well, there's a lot of junk here going on.
Well, there's a 40-minute break, and you can see the defendant's demeanor at the end of the first part of the interview, and the defendant's demeanor at the beginning of the second interview. He's calm, he's low-key, he's smoking a cigarette, and he agrees that he, on his own, twice, he agrees that he decided to reinstitute the interview.
He says uh-huh twice. Yeah, right.
Very calmly.
Yeah. Okay.
Do you
And there's
think,
no evidence to the contrary.
Attorney McMahon, do you think that when you read the judge's memo, as opposed to when you watch the tapes, you take away a different opinion about what happened? Or is that possible? You know what I mean? Like if I just read the judge's decision, I'm left with an impression. If I watch both tapes, what impression am I left with? Is it different?
Yes, because I don't think the judge took everything into consideration. He ignores what the defendant does in the second interview. He claims that it's only Detective Canini, and Detective Canini's testimony, which he doesn't discredit, doesn't rise above the preponderance standard. But Detective Canini is corroborated twice by the defendant, and we have nothing to contradict that except for speculation.
Do we have any case law that specifically identifies how to determine the difference between a preponderance of the evidence and reasonable doubt in this context?
I don't know. I'm sorry.
Thanks.
I'd like to ask Justice Seifer's question in a different way. because I think it's a really important, interesting question. Judge Ferrara, on this evidence, I have to agree with you, could have found that the defendant reinitiated the conversation beyond a reasonable doubt. But if you take, and I won't list it now, and I could add to the list, everything Justice Kafka put into his question, and what Judge Ferrara wrote at the end of his memorandum in order, and the amount of times that the defendant had to say at the end of the first interview he wanted a lawyer, that Judge Ferrara could have found proof beyond a reasonable doubt, but he was the trier of fact, and he didn't. Why wouldn't we affirm him if that's our analysis?
Well, this is a hybrid situation because you've got the documentary evidence of the two-part video, as well as what he found from the testimony at the suppression hearing. And you can take your own take about what was on the video. And I don't think Judge Ferrara considered anything that the defendant said in the second part of the interview. He described what Detective Pogorski said to the defendant as self-serving, but he didn't acknowledge that the defendant agreed with Detective Pogorski and then again agreed with Detective Canini about what happened and his demeanor, and he just didn't want to get yelled at. That was what he had said when he wanted to reinitiate the interview. Then at the end of the interview, a state police detective and a Holyoke police officer wanted to speak to the defendant about a different case, and he agreed to that as long as he wasn't yelled at. So it was the 40 minutes. We've got nothing about harshness at all. It's just a general conversation and an explanation of the booking process, taking the defendant to the bathroom, giving the defendant a cigarette or cigarettes, and then his calm demeanor in the second part of the interview where nobody's yelling.
So what you would say is you've got the video and you have the judge crediting Detective Canini and never indicating that he didn't credit Detective Canini. So how do you not get to proof beyond a reasonable doubt?
When there's no evidence contrary to what Detective Canini said. It's not like a dispute in the evidence. There's no opposite evidence.
You also have got the other factors. The captain's just come in screaming at him. It's not every day you get the captain of the police force screaming. Does he seem to, he knows him from some reason as well? Do they have some prior encounters, the captain and this guy?
There's nothing in the record about a prior encounter. I think he knows something of the defendant's background.
And then I just looked at the decision. Canini goes, F it, call them and turning it off. Canini can be heard crumpling a paper. Stop talking, stated angrily. So it's, there's, Canini's, not some guy who's just like had a pleasant, he's not the good cop here. He's left behind. I mean, I don't know, there's a lot. The booking process, the police have no explanation why no one took him to the booking process either. I don't know, it just seems like there's a lot going on here besides.
Well, they do have an explanation.
We have a lot of these cases where another police officer shows up who's friendly with the defendant, and that the defense says, "Oh, I'll talk to you," but suddenly, he's changed his mind after talking to the person who's just, angrily, gotten mad at him.
Well, Attorney McMahon, you said there is in fact something, but it's not in the judge's findings. Is that right? But it's in the record with regard to why he didn't go to booking?
I think Duda and Detective Martucci explained that homicide defendants are treated differently than other defendants. They're not brought down to the booking when there are other defendants there to be booked. They're booked separately. They're held in a cell separately. Their concern is about, there's a suicide concern. So there's not a camera watching them in the cell, but there's actually a police officer who watches them constantly. This defendant was in the detective bureau. He's in an interview room. He had to be watched. And then the reason why the audio and video was shut off is because at the end of an interview, the equipment is shut off. And that's what happened here. It's nothing sinister. That's what happened. And it was turned back on again when the defendant decided to continue with the interview.
Everybody all set? Okay. Attorney Elkins.
Chief Justice Budd, Justices of the court, may it please the court. I ain't gonna talk. Edward, now is the time to tell us. Very shortly thereafter, can I call my lawyer? So he's asking in Spanish. So he's asking for a lawyer. You want what? My lawyer. You want my lawyer? Yeah. He goes on, and as Justice Lowy points out, goes on, call my lawyer. Okay, he's going to turn this off. We're going to stop interviewing you and you'll be booked for murder. You're going to be booked for murder. All right, call my lawyer. You can call your lawyer later on. Can you have them turn off room A, please? Yep, have them turn it off. Because right now, Mr. Gonzalez, Canini, stop talking. You just said you want a lawyer. We can't talk to you. Before that, F it, call them and turn it off, Canini says as he crumples up the paper and throws it in the trash. Cursing and angry, they call for the video to be turned off. Police tell him that he's going to be booked for murder, but he isn't. Instead, he's left alone in the same interrogation room with one of the same officers who'd been interrogating him. And as Judge Ferrara found, based on the totality of the evidence, he continued to speak with him with the intent to persuade him to reverse his invocation. That finding regarding his intent was supported by ample evidence from the evidentiary hearing. And ultimately, they did have him talking again. It's been commented on that there was, the Commonwealth suggests that there's no evidence to the contrary about what they talked about. But the fact is that experienced ranking members of the Springfield Police made deliberate choices to not record when they could have, not preserve evidence that was available, and to eschew the simple professional step of making contemporaneous notes or reports. So when many months later, they're called to testify about this undocumented gap, Judge Ferrara found that their inability to offer the reliable, specific testimony meant that they failed to meet their burden to prove beyond a reasonable doubt that the interrogation had actually ceased, and if it had, that Mr. Gonzalez had reinitiated it, and that in the totality of the circumstances that a subsequent waiver was knowing and voluntary. Now that was the Commonwealth's burden beyond a reasonable doubt. And as soon as Mr. Gonzalez said, I ain't speaking, that was a moment of legal significance that whether anything changed for Mr. Gonzalez or not in that room, which it did not for the most part, changed something significantly in the legal respect for the Commonwealth. Now, Judge Ferrara's decision relies most clearly on a finding that he harbored reasonable doubt that Mr. Gonzalez, and this is quoting his...
We've never said, in Giambattista, we said that you should record interrogations. And we have lots of cases where people change their mind. We can't expect the police to have a camera rolling every time. So there's an invocation, an inappropriate reaction to that by a police officer, and they appropriately shut the tape off. So you want us to draw a negative inference from the fact that they didn't record him thereafter?
What I am suggesting is that Judge Ferrara took a negative inference, and that was completely justified under the circumstance. The thing about just
the legal question is whether or not that inference is warranted by the evidence, or whether it was speculative as found by the appeals court, right?
I would agree with that, Your Honor. What I would suggest about Giambattista, and particularly his relevance to this case, is that Giambattista is not about whether or not, it wasn't a dicta that they had to record and prescribing certain circumstances where they had to record. What Giambattista said is it's about making sure that the fact finder in that situation, jurors who might be prone to unconscious biases regarding police testimony in circumstances where there's a great deal of reason to note that it could be problematic, understand that they can take a negative inference, that it is permissible in that situation. Now, Judge Ferrara, of course, is the fact finder, and of course he also understands and understood very well that he could take a negative inference in this circumstance. And that is not speculation. It wasn't speculation on his part to find, to take that negative inference,
But
because he had.
What about when we go, what they do, when someone reinitiates, the next step is to put them on tape again and say, hey, you wanted to talk to us. And that's what they did here, correct?
They did, and as Justice Ferrara said, that standing alone told us nothing about the 40-minute gap, which was what really is the point of inquiry. I'd point out two things about the two. There were two very, very brief exchanges that were meant to encompass this whole 40-minute period, or this reinitiation. One comes at is Detective Podgorski, who does the initial Miranda warning with, of course, Canini present. Now, the testimony, just that, if it had just been that video that the Commonwealth had presented, which of course bearing the burden, they could have chosen to do that, but clearly seeing that it was insufficient on its face, they brought in the officers who were involved to testify. Now, it's not clear on that tape, but what Judge Ferrara learns in the motion hearing is that Podgorski, by his own testimony, was not present for the reinitiation. He could not, under oath, say how he knew about the circumstances of the reinitiation, what exactly was said, and in fact testified that he didn't recall that anybody had told him. So when he says on the tape, we took you to the bathroom and then we were taking you to booking, that is, one, factually inconsistent with Canini's version of how the reinitiation happened, and it's not clear that it's even what knowledge that's based on. So Judge Ferrara's finding that was self-serving and told us nothing about the facts and circumstances of the initiation is amply supported by the totality of the evidence that he heard. The fact that
the Commonwealth's argument here is pretty straightforward. First of all, on Commonwealth under Commonwealth versus Tremblay, we can look at the end of the first interview, which I have, and we can look at the beginning of the second interview and independently think about what that demonstrates to us. And then we have the fact finder saying that that he credits Canini. He doesn't indicate any part of the testimony that he doesn't credit him. And what we have is what the video says and corroboration from the video, and we have crediting of Canini, and certainly at a minimum not discrediting Canini. And the question is, from the Commonwealth perspective, isn't that proof beyond a reasonable doubt? And if it isn't proof beyond a reasonable doubt, well, what exactly are you discrediting?
Your Honor, there doesn't have to be. First of all, I disagree that any of Judge Ferrara's decision should be interpreted to be a wholesale acceptance of Canini's testimony and crediting in its entirety. The other thing that I would say is that Canini's testimony in and of itself was vague and self-serving and not specific. So, and to the extent that Canini attempted to try to convey anything about the general talk that went on in between that, he tried to characterize it as not about the case, and he tried to convey that there was not an intent to change the waiver, that it had nothing to do with that. And that Judge Ferrara explicitly rejected. So, and I think part of the difficulty here is that it is one thing to say that a witness has testified that a car is blue. I don't find that credible. The car was yellow. I don't believe that they saw it. In this case, Canini's testimony is an attempt to characterize the nature of the discussion and the words that were said in between them and in the context of that 40-minute gap. The analysis of whether or not the functional interrogation, equivalent of interrogation even took place, cannot happen in the absence of the specific, some fairly specific understanding of what was said. A conversation doesn't have to be about the case to be the functional equivalent of interrogation. One can imagine sitting down and oh, well, we talked about sports, which Canini was specifically asked, did you talk about sports? And he couldn't recall. But sitting down and saying, I can't, I love the Red Sox and I can't imagine going the rest of my life and never, being able to go to Fenway Park again and see the Red Sox. Well, that's not about the case. But in the right context, a conversation about anything can be coercive in the sense that we talk about with for Miranda.
Sort of a long way to get. Maybe, and I'm not going to speculate. Maybe the conversation wasn't particularly remarkable, but it's hard to take the evidence that we have and say that the 45-minute conversation was the functional equivalent of interrogation. What we got is, question about the booking, go to the bathroom, and then decide that he wants to talk again. Well, and then we have a video that corroborates that he wants to talk again. That's the simplicity, and just because it's simple doesn't mean it's not right. Straightforward argument to the Commonwealth.
I would suggest two things about that. One is that it is supplanting Judge Ferrara's decision with a separate finding of its own to find that the interrogation actually did cease, simply because as the Commonwealth has always said, they pushed stop on the recording. After that point, it's a black hole of information, a virtual black hole of information. And in Judge Ferrara, he used, while he did not specifically say, I find that the interrogation continued, he did note the continuation of conversation. The interrogation circumstance continued. If anything, tactics, and there's evidence from the motion hearing to this effect, that things like giving cigarettes and putting people at ease in the context of their interrogating officers are tactics. So the interrogation circumstance continued with the same, he's in there with the same officers who were in with him, the only Spanish-speaking officer. So first of all, I would suggest that to adopt the Commonwealth's position, which they argue, which they just put out by fiat without any argument as to why it constitutes cessation, but to find that the interrogation actually did cease simply because they pushed stop on the video player, video recorder is to supplanting one of Judge Ferrara's important findings.
I understand what your argument is there, but can I take you, if this is if Judge Lowy's satisfied, to just a different point, and that is when let's assume interrogation stops, as after that, when they press the button and they say, okay, we're not talking anymore, whatever. Don't we need evidence that the defendant initiated the desire to speak to the police again?
We do. Yes,
so what is that in this case?
Well, I would say that that's the Commonwealth's burden.
Well, yes, but you must have a view of the evidence, and you can say it's there or it's not there, right?
I would suggest that the testimony, the Canini's testimony about that 40-minute period, and as I said, was vague and inspecific and not specific, but he did talk about this trip to the restroom and these booking questions. He was asked on cross-examination if he recalled exactly what they talked about during this general conversation, that he admitted, as he said, we talked. Oh yes, we talked. He was very adamant that they talked throughout. I think a very specific and a very important point is that on cross-examination, he was asked if he recalled whether or not there was any pause or break in this general conversation before Mr. Gonzalez purportedly said, I'll talk, I just don't want to be yelled at. And I would suggest that if this general chit-chat, if we can't even recall the sequence and how long there was pause. It was 40 minutes. It's a pretty long time to be not taken to booking when you've been told to be taken for booking. And I would point out that there was no evidence specific to this case, to your earlier question, Justice Cipher, as to why he specifically wasn't taken. And I can address more points about that. But this was a pretty long period of time to not be taken to booking, but it was not that long of a period of time to be able to say, and Detective Canini could not say, whether or not they sat in silence for any period of time. I think an interesting case to note, and it's a simple case in some ways too, is Commonwealth v. LeClaire, 55 Mass App Court 238. And what I find significant about that case is that there's an invocation, and the defendant in that case is left alone with the officer, but that officer is given specific instructions to not talk. Compare that to here, where you have experienced officers who are very interested in motivating the case, all findings of fact by Justice Ferrara, and Canini is not instructed how to comport himself, and he's not instructed to write a report after the fact. He doesn't object in the initial portion of the recording when Podgorski gives a different recitation of how the reinitiation happened. And he does nothing to preserve his memory of what this is. And so, yes, was this important in retrospect, in hindsight? The import of this 40 minutes, perhaps, but I would suggest for the officers who were knowledgeable and understood, it was important immediately in retrospect. As soon as they turned that video back on, they knew this was something that was going to be the subject of litigation and questioning what happened during that 40 minutes. And I think the evidence.
It's a reification. They know that if someone invokes and then they give an interview number 2, of course it's going to be subject to litigation. So you're drawing an inference it was sinister because they asked about the initiation?
Your Honor, I am suggesting that is the basis of Judge Ferrara's negative inference about their failure to record, and not just their failure to record, but to not write reports, to not make contemporaneous notes, to not monitor when there was a great deal of evidence that they could have live monitored even if they weren't recording. And that is the most significant part of evidence that Judge Ferrara.
It all turns on whether or not the inference he drew was reasonable, and that's for us to decide, correct?
It is for you to decide. I would suggest that the standard being, because it's a mix of recorded evidence and live evidence based on it, that it's entitled to de novo. I see that my time is up, but I just want to briefly,
before you conclude though, I'm just trying to get because the tricky issue is the credibility issue on what happened in the general talk. And I can't figure out what the judge is saying, because the judge kind of says, if the Commonwealth argues this, and if the burden of proof were only preponderance, what do we make of that? Particularly when it follows the next paragraph, which is sort of very suspicious of Canini being displeased, blankety. Do we have a fact finding here that credits or not? What do we do here on that point? Because this may all turn on whether he found him credible on the general talk point, but I can't figure out what he's saying.
I would suggest 2 things. One, I suggest that there isn't a general finding of credibility for Officer Canini, as if you look closely in Judge Ferrara's facts, he always prefaces Canini's with he testified to. That is not necessarily, he doesn't say one way or the other. I mean, that's just a factual statement of what he said on the stand. He doesn't say one way or the other as whether or not he credits.
Is the key sentences on this the ones on 8? The Commonwealth argues that all that is required is a credibility assessment. If the court credits Canini's assertion that he and Gonzalez did not touch any aspect of this case during the interim period, then the Commonwealth has met its burden. If the Commonwealth's burden was a mere preponderance of the evidence, Canini's testimony might suffice. I don't know what that means.
Candidly, it's difficult to parse. What I'd suggest two things about that though. One is that Judge Ferrara, it clearly indicates that he understood that the burden of proof was on the Commonwealth, and it was a high one of proof beyond a reasonable doubt.
Is that confusing two different burdens of proof? We don't have burden of proof on each statement to be beyond a reasonable doubt, right? We have only, you know, the ultimate burden of proof is beyond a reasonable doubt, whether he reinitiated voluntarily. But the issue of whether what they talked about in that general statement is a preponderance proof, isn't it? Do we apply beyond a reasonable doubt for every single fact found in, you know, I just don't know if we do that.
Oh, I don't know that we do. What I would suggest though is that the question of, you know, perhaps if it were not about the case, if the discussion were not about the case, it would meet by preponderance of the evidence. If you're looking at the question of whether or not that's enough to say not, if true, like not about the case, that was more probably than not the functional equivalent of interrogation.
I just can't figure out, because the next paragraph, the judge talks about all of Canini's incentives to restart conversation with the defendant. So it seems like those two statements don't give us any clear answer on credibility. If I look at page 8 and page 9, I don't know whether the judge found Canini credible or not credible. I just can't figure out what he did. Does he say elsewhere in the opinion that he finds Canini credible? And I missed.
He never says that he finds him. He never says specifically that he finds him credible, and I think it is stretching the bounds of whatever it was he was trying to say about the preponderance of the evidence to stretch that into that finding. He did very specifically, though, in kind of a muted form, find other portions of other officers' testimony very specifically not credited, which the Commonwealth, for its part, has said he just simply wasn't entitled to find, which seems like not a proper application of the standard. If I may just, and very briefly, I would point out that in the interim, while we've been waiting for oral argument in this case, the appeals court came out with Commonwealth v. Davis, 98 Mass. App Court 604. It's a very analogous case, and I would suggest properly applies the standard of review in this kind of case where there's a mix of recorded and unrecorded portions of evidence. And I would just suggest it would be very difficult to reconcile a reversal in this case with that decision. Unless there's any further questions, I would rest.
Okay. Thank you, counsel. We'll take a break for 5 minutes.
Thank you.
Thank you.